Your Honor.
Ms. Allen, you ready?
Yes, I am, Your Honor.
Okay, all right. This is a time set for oral argument in Rodriguez versus Lytle, our case CV20 0048. Counsel, good morning. We are proceeding electronically given the COVID-19 issues. And as I mentioned, if one of the judges falls off, given some technical issues, please continue. We'll catch up. Our proceedings are being recorded. If one of you fall off, we'll wait till you come back because we can't proceed without your presence. We have reviewed the case file. We have reviewed your briefing. We've conferenced the case. We would encourage you to keep that in mind as you proceed with oral argument. If appellant wishes to reserve a portion of your time for rebuttal, you're free to do so, but you need to keep track of your own time. And as I mentioned before we went on the record, I'll keep track of it on my my smartphone here as well. With that, and recognizing our proceedings are being recorded, I would ask that you please tell us your name and the party that you represent as you begin your oral argument. And with that, Mr. Levin, am I pronouncing your name correctly?
Actually, it's Levine, Your Honor.
Levine, I knew it was one of the two and I guessed wrong. I apologize, but you may proceed.
Thank you, Your Honor. As indicated, my name is Mick Levine. I represent the estates of Iran and Roger Gamez. May it please the court. This is not a wrongful death proceeding. At least this part of the case is not a wrongful death proceeding. This is a survival action pursuant to ARS 143110. Now, the survival action is a statutory construction, and the statute basically indicates that an action can be made based on the claims that a person who died still has after their death as represented by their estate. In this particular instance, the estate is claiming damages for loss of future wages and income. The loss of future wages and income that's being claimed is something that is normally claimed by a person who's injured in a personal injury action. If, for example, we had somebody who was catastrophically injured and unable to work, that person who was catastrophically injured and unable to work would be able to claim the loss of future wages. In this case, we're asking for the same thing, only for the estates of Iran and Roger Gamez. Now, looking at the statute itself, it's relatively clear what it says. It indicates that every cause of action, except for a cause of action for damages for breach of promise to marry, seduction, libel, slander, separate maintenance, alimony, loss of consortium, or invasion of the right of privacy, survives. Now, loss of future income, not listed in one of those actions that does not survive. The statute does go on to indicate that damages for pain and suffering of such injured persons shall not be allowed. Loss of future income is not damages for pain and suffering. If the legislature intended not to have a claim for the estates of somebody who had died for loss of future income, they could have done so. They indicated in the survival statute exactly what actions that a person who died was not allowed to bring. They indicated.
Let me ask you. We're not writing on a clean slate, though, are we? Haven't there been cases that have construed what this statutory text means, tracing back, for many decades?
Yes, there have been some cases that have talked to these issues. In fact, the Berrigan case that the Court of Appeals decided 50 years ago did talk a little bit about this issue. And what the Berrigan case indicated was that the wrongful death action is confined to the damages the death caused to the statutory beneficiaries, while a survival action is for the wrong done to the decedent. The deceased person in this case is Iran and Roger Gamez, and their estates are claiming those lost wages that they would have had they not been killed by this unfortunate incident.
Does your reading of Berrigan, though, cabinet what window of time those damages can be sought for? Let me ask a better question: does your reading of Berrigan limit such a claim until such time as the person passes?
So the Berrigan court wasn't presented with a loss of future wages claim. And what they indicated was that the claim for the estates, what it did was it had damages for the estates for the person who passed away. And then where that claim ended, a claim for wrongful death began. Now, the Gandy case, a federal district court case that came along a few years later, they interpreted that to mean a temporal meaning, meaning that they believed that where the person died, their claim ended. And when the person, the wrongful death beneficiaries, they picked up the claim after that. But Berrigan itself really was looking at preventing double recovery. And in fact, the Gandy opinion says pretty much the same thing. We want to prevent a double recovery. And so while the Berrigan court indicated that the wrongful death claim picked up where the statutory beneficiary, where the estate claim ended, it didn't actually put a temporal time period on that. Rather, what it was really looking to do was to prevent a double recovery for both the estates and the wrongful death beneficiaries. In this particular case, what we've done is we have not made a claim for future income that Iran and Roger Gamez could have contributed to the wrongful death beneficiaries. That is not a claim that was made in this particular case. The only claim that's made regarding loss of future wages for Iran and Roger Gamez is within the survival claim, solely for the estates, not anything that the wrongful death beneficiaries are going to be claiming at all. Now, there's a reason for this, of course. Iran and Roger Gamez were teenage boys without a history of income at the time of their death. And so it becomes an evidentiary concern as to whether or not they would have given anything to their parents should the parents make that claim. And we felt it was just too speculative to try and make that claim. But what we could do is we could use an economist, an expert in the field, in order to determine what Iran and Roger Gamez would have earned had they lived to their natural lifespan, out from their earnings, what their consumption was. And that's basically what the estates are claiming here. So
what is your best case under Arizona law for recognizing under the survival statute a claim like you are making here?
Well, so the Arizona courts haven't actually addressed whether or not the estates can maintain a survival claim under the 143110. Rather, two federal courts have really looked at this particular issue, and that's Gandy and Mannion. Gandy concluded that we don't want double recovery, and so we were going to only permit this claim to be made by wrongful death beneficiaries. But in that claim, there was overlapping claims. There was a claim by the wrongful death beneficiaries for what the deceased would have provided to the survivors, but there was also a claim made for the estates. The Mannion claim is almost exactly the same as this claim. In Mannion, what happened was that the estate claimed future wrongful death proceeds, whereas the wrongful death beneficiaries did not claim any contribution from the person who passed away. The Mannion case is better reasoned. In that case, what they did was they looked at the statute and they said, look, if the legislature had intended to prevent future lost wages from being claimed by an estate in a survival action, they would have said so, but they didn't. And so because they didn't say so, then it became more a matter of the evidence and the pleadings and that sort of thing. Yes, there was the concern, even in Mannion, it was expressed, we don't want double recovery. But in Mannion, just like this case, there was no chance of double recovery because the wrongful death beneficiaries were not claiming any contribution.
So counsel, in the Berrigan case, when it says, quote, in general, a survival statute provides for recovery of damages sustained by the decedent party from the time of accident until his death. How does this case fall outside of that, other than the in general, I guess, precedent? How is this case different from that?
I would submit, Your Honor, that first in the Berrigan case, they didn't even address the issue of future lost wages. What they were looking at was medical bills for the decedent before he passed away. But what they say in Berrigan, and I'll represent that my reading of the Berrigan case indicates that that portion of it is dicta. It wasn't necessary to the holding in the case. But even if you look at the actual words that they say, the latter begins where the former ends, and a recovery on both is not a double recovery. What they were really looking at was they don't want a double recovery here. And that's exactly what we have in this case. There's no double recovery. So when they say that the damages for the estates in the survival action stop with when the person passes away, what they're really looking at is at the time that they pass away, what are their damages? And I would submit, Your Honor, that their damages at the time that they pass away include future loss of income or future lost wages that the person would have had they survived. So if you look at strictly a time period here, when do their damages stop for the estates? When a person passes away, they have those damages at that time for whatever income they would have earned in the future. Hopefully I answered your question adequately, Your Honor.
Yeah, I think you're saying that was dicta.
Not only was it dicta, but I mean, if you look strictly at when they died, what claim they had, at the time of their death, they had a claim for future lost wages. Just like at the time that a person is crippled and cannot work at all for the rest of their lives, they have that claim for future lost wages right at the time of their injury.
So, but you don't have, to go back to Judge Thumma's decision in the, I think you said 70 years, not 70, feels like it, 50 years. 50 years since this case, there's no court, Arizona court, that has addressed or clarified the issue or labeled this as dicta or gone in a different direction, or you don't have any case for that in the 50 years?
As far as looking at a claim for future lost wages or future lost income to an estate and a survival action, the only two cases that I was able to find that directly address this issue are in federal court, and they're the Gandy and the Mannion decisions. I don't see anything else in Arizona that directly addresses this particular issue.
Thank you.
So when we're looking at the statute itself that the legislature enacted, and we're trying to determine what exactly was it that the legislature intended, we just need to look at the plain words of what it is that they're saying. They didn't include an exception to the survival statute that would take away a claim for future lost income or for future lost wages. What they did instead was they took away a claim for pain and suffering, and they also took away several specific types of claims, but this claim was not amongst them. And the legislature is presumed to know what it is that they're legislating. They're presumed to know the body of law that's available, and if they wanted to exclude this particular cause of action, they certainly may have done so. We understand there is a concern about double recovery, and in order to prevent double recovery in this particular case, there just isn't any. The estates are solely the parties who are making a claim for future lost wages. And if there's to be any award from a trial for future lost wages, that would go solely to the estate. In this particular case, you don't have any overlapping claims. You don't have the same concerns that you do in Gandy. Rather, you have the situation that arose in the federal court in the Mannion decision. And one of the other things that I thought from the Mannion decision that was very on point was that courts shouldn't be the one deciding who gets to make which claim in this particular regard. The parties are the ones who frame the issues, and the parties are the ones who get to make what claims they wish to make, so long as the law supports it. And while Berrigan does have some,
let me ask you, and Berrigan as saying that the damages window is from the for the survival statute is from the injury to the time of death. And I understand that's not your position. Your position is to the contrary. But if the court were to construe that, what would the effect be on the claims for the two young men here?
Well, Your Honor, my position is that even if the injury window is from the moment of the injury until the time of death, I would say at the time of death, they have a claim for future lost wages. I don't believe that that claim arises after the time of their death. I believe that that claim arises at the time of death.
And I understand that. But bear with me, and I can put it into a hypothetical if you want. If someone's injured on day one, month one, dies 10 days later, and this court construes Berrigan as saying it's that 10-day window of damages that we look at, not for future damages, but that 10-day window. If we were to construe Berrigan that way, what would it do for the claims, the statutory survival claims for the two young men here?
If you were to construe it that way and to indicate that future lost wages is actually not a claim that would fall within that window, then for these two young men, we would still have remaining burial expenses and medical expenses that were incurred. One of these young men was pronounced dead at the scene. The other actually was treated at the hospital and does have a hospital bill. But that's only if you consider that the time that a future lost wage claim arises is after their death, somewhere outside beyond that window. But I believe that Berrigan can be reconciled with plaintiff's position in that that claim arises as soon as those boys passed away, and that it is within the Berrigan window. Now, again, though, Berrigan's a 50-year-old case. It's not in keeping with how modern day works. Berrigan was very much concerned with double recovery, and the way that this complaint was stated reduces any risk that there would be a double recovery under these particular facts. Absent any additional questions, I'll reserve my time.
Mr. Levine, let me look to my colleagues. Any questions? Judge Williams, I think you're on mute.
Thank you. Mr. Levine, just a quick question. I hear you loud and clear on the double recovery issue that I think Mannion, I'm looking at Mannion now, that touches on as well. But as far as the survival statute, that statute 143110, although it was numbered differently, I think back when Berrigan was decided, you would agree that that statute hasn't changed substantively pre-Berrigan versus post, correct?
I would agree that it has not changed pre-Berrigan versus post. The language is very much the same. The only thing that's changed was the numbering, as far as I can tell. But in anticipation of another question here, Berrigan also did not address our particular issue, which was a claim for future lost wages as a result of the death.
Okay. Thank you.
Thank you. And Mr. Levine, time goes very quickly, but I have you sort of generously at about 2.5 minutes left for rebuttal. So,
thank you, Your Honor.
Ms. Allen.
Yes, good morning. May it please the court. My name is Lynn Allen, and I represent the defendants, Appellees, Justin Lytle, Larry Lytle, and Tracy Lytle. Our position is that the estates do not have a claim for loss of future earnings because the decedents did not sustain a loss of future earnings at the time of their death. They did not have such a claim, and therefore the only damages recoverable by, and those are the only damages that are recoverable by the estates in a survival claim, are those damages that had accrued as of the time of death. Our position is that the trial court made the proper ruling. This is not so much an issue on appeal as to the statutory construction of the survival statute, but rather whether the Court of Appeals decision in the Barragan case sets that window for damages recoverable in a survival action. So there are two types of claims present in this lawsuit. There's the wrongful death claim being asserted by the parents. There is a survival action being asserted by the estates. And so the survival action is a creature of statute. But what's important to know is that the survival statute doesn't create a new cause of action. All the survival statute does is change the common law. And this is discussed in the case law, that at common law, once a person passes away, their claim for personal injury against a tortfeasor abates. It can no longer be asserted. The survival action or statute was enacted to allow the estate of the decedent to pursue that claim for personal injury against the tortfeasor, notwithstanding the death of the plaintiff. So what's important to know is what claim existed in Roger and Iran's, for Roger and Iran, what personal claim existed at the time of their deaths. One of the boys died instantaneously. The other passed away at the hospital shortly after he was transported. So that's the window. The window is the time frame from the accident when they were injured until the time of their death. Did they have a claim for damages, and what was that claim? And so what I want to talk about is Barragan and why we believe Barragan answers the question.
Ms. Allen, before you get there, and I want to hear you on that, with respect to the instantaneously, where would we find that in the record? And that's for Roger, as I understand it.
That's correct. So, goodness.
Let me give you a little more context. We're here on a 12C at the scene. It doesn't say he passed away instantaneously, and that's why I ask.
Your Honor, so we would have to go with what the pleadings say, and so we would have to go with that he passed away at the scene. So we don't have an exact time of death. So I may have misspoke.
No, I wanted to better understand that. Now you were gonna turn to, and that's helpful to me. You were gonna turn to Barragan.
Yes, so in Barragan, we had a similar situation where a person was killed as a result of, well, later passed away as a result of an accident. In Barragan, the plaintiff was injured in an accident, survived for approximately 1 year, and then passed away. And there were two claims presented, as they were in this case, the claim by the wrongful death beneficiaries, as well as a claim by the estate under the survival statute. And the Court of Appeals initially affirmed the dismissal of the survival action, finding that those two remedies were mutually exclusive. And then on rehearing, reversed itself and found that the wrongful death claim and the survival action were not mutually exclusive because they covered different claims. And in doing so, the court explained, as I discussed earlier, that the survival statute merely revives or allows the claim that existed at the time of death to be pursued by the estate. And that the damages that had accrued up to the time of the death would be recoverable. And in doing so, the court discussed at page 404, the quote stated, quote, "In general, a survival statute provides for recovery of damages sustained by the deceased party from the time of accident until his death. Such damages include expenses incurred necessitated by the injuries in the nature of hospital and medical expenses." Now, in fairness, this court was not presented with the issue of future loss of earnings, but we can take from what the court says, damages incurred while the plaintiff was still alive. Those damages would be loss of earnings that were incurred during the time the plaintiff, the decedent, lived. In this case, in Baragon, the decedent lived for a year. So presumably, if she had a loss of earnings, that claim could be brought. But a loss of earnings claim ceases upon the death of a person. They no longer have future loss of earnings because they have died. There is no longer a claim, and that's why the plaintiffs, or the decedents in this case, Iran and Roger, do not have a claim for future loss of earnings. They died within a short period of time of their injuries. They incurred no past loss of earnings, and they incurred no future loss of earnings because they are cut off as of the time of their death. And so that was the basis for the trial court's decision, and that's the basis for our position, is that they simply had no claim for loss of future earnings at the time of their death. It's not an issue of double recovery or preventing double recovery. And I want to segue into that because it's something we didn't really speak to in our briefs, but which is important to look at. And I think the trial court picked up on this. The measure of damages in a personal injury case is different than the measure of damages in a wrongful death case. And in a personal injury case, and I'm looking at the Raji personal injury one, the plaintiff can recover his personal loss with regard to loss of earnings. It states loss of earnings to date and any decrease in earning power or capacity in the future. So we've been talking about a loss of future wages, but what really Roger and Iran would have been entitled to seek had they lived would be a loss and a decrease in earning power or capacity in the future. They did not live. Therefore, they did not suffer or sustain a decrease in their earning power or capacity in the future. Now, when you contrast that to what a wrongful death plaintiff can recover for the loss of a loved one, is much different when it comes to earnings. And this is the Raji Personal Injury 3 instruction. The wrongful death beneficiary can recover the income and services that have already been lost as a result of the death and that are reasonably probable to be lost in the future. That's not a claim for loss of future. That's a claim for loss of future support. So it's really two different things, and I think it's been conflated in the arguments that have been made by the appellants in this case. So our point is this. Baragon says the window of time for damages that can be recovered in a survival action are those damages that had accrued as of the time of the death of the plaintiff. In this case, there's no allegation, there was no allegation in the complaint supporting any finding that Roger and Iran sustained any loss of income between the time of their injury and the time of their death. And for that reason, the trial court correctly dismissed the claims of the estates. Now, I do want to address, I know one of you had a question for Mr. Levine about what damages could be pursued by the estates for that time period, that window. And Mr. Levine said burial and medical expenses. I would just point out that that would certainly be anything incurred by the children during that time frame. So burial expenses would not be incurred by Roger and Iran prior to their death, because they didn't arise until after their death. So those would be claims that the parents could make in their wrongful death claim. With regard to medical expenses, and I assume if this is remanded and the trial court's decision stands, again, there's no allegation being made in the complaint that Roger or Iran personally incurred medical expenses before their death. Again, that would be expenses incurred by their parents because they were minors at the time. They would be expenses incurred by their parents that would be recoverable in the wrongful death case. So I did want to address that. Going to the issue of statutory construction with regard to the survival statute, an argument's been made that the legislature could have, had it intended to, expressly excluded future loss of earnings from the survival statute. Our position is that it was not necessary to do so. And the reason why it wasn't necessary to do so is because the concept underlying a survival action is that the claim of the decedent as it existed at the time of death survives the death and can be pursued to completion by the estate. Therefore, it's really an issue of an evidentiary issue as opposed to a statutory construction issue. Did the decedent have a claim for loss of earnings at the time of death, and if so, what is it? So it wasn't necessary for the Court of Appeals to, I'm sorry, for the legislature to even address loss of earnings. The reason why pain and suffering is addressed in the statute harkens back to the restatement and to the law in other jurisdictions. Under the restatement, it is noted that survival statutes in general allow the estate to recover pre-death pain and suffering of the decedent. So you'll see in many of the decisions throughout the country, and let's just use this case as an example, the estates would be allowed to bring a claim for Roger and Iran's pre-death pain and suffering. That's allowed in many jurisdictions throughout the country under the normal wording of survival statutes. The Arizona legislature made a decision that it would not allow that recovery in a survival action, and that's why it's excluded. Otherwise, it would be just as pre-death wage loss and pre-death medical expenses would be recoverable in a survival action. So to the extent there's curiosity or leaning toward, why the legislature would use that language in the statute, that would be the reason why. I know I have about 5 minutes. I don't know that I have anything else I need to expressly address. Well, maybe the Mannion case, I think, I would just point out that court was very focused on statutory construction and really a reliance on the notion that the Barragan case and the Gandy case turned solely on duplicative recovery of wage loss. Those cases did not. Barragan focused on the window of time that the survival action allows a recovery for damages by the estate, and that would be from the injury to the time of death. The Gandy case also focused on Barragan's holding with regard to the two, and did note that clearly that would preclude a double recovery if the estate, or I'm sorry, if the wrongful death plaintiffs were claiming a loss of support, but that certainly wasn't the reason for the decisions.
So, counsel, are you aware of? I'd asked whether your colleague is aware of any case in Arizona in the intervening 50 years that either clarifies or addresses the issue. Are you aware of anything?
No, Your Honor, I'm not. And I did read a lot of cases preparing my briefs, and I'll be embarrassed if one turns up. I could not find one that applies to this issue or even it comes close. Barragan seems to be it. And as Judge Williams noted, the statute is identical. It has a different number, but it is identical to the statute that the court was dealing with in the Barragan case 50 years ago.
What about your colleague's argument that 50 years have elapsed since Barragan, and maybe it's time to look at it based on, I think you said, sort of modern ways things are done?
Well, I guess I would disagree with that. Nothing has changed. I don't know what these modern ways are that Mr. Levine speaks of, other than he and Mr. Black have come up with this argument that was successful in Mannion. It's been 50 years since Barragan, and this is the first time the court is being presented with the issue of future loss of earnings under the survival statute. And I would submit, because everyone knows they're not recoverable in a case where a person has died following an accident and has not incurred any loss of wages. There's nothing that's changed in 50 years. If a person has incurred a loss of earnings before their death, the survival statute has always allowed that claim to be brought. And there's nothing, there's nothing unusual other than, as Mr. Levine noted, in this particular instance, Roger and Iran were teenagers and did not provide support to their parents. And their parents would not be able to prove to a jury that they would have done so had they survived. That's really, the crux of the issue here, is that the plaintiffs don't have a claim. The individuals do not have a claim for loss of support. And this is a way for the plaintiffs, who are the beneficiaries of the state. Let's not have a fiction here. They're the beneficiaries of the estates, for them to recover additional money from my client.
So is that a separate basis, the speculative nature, this sort of prospective speculative nature of this damage?
Well, I think it's something the court can consider, but that was not the basis for the trial court's decision. And again, it was on a Rule 12C motion for judgment on the pleadings. So our position is, certainly we would make that argument if this case goes back to the trial court. But the basis is that there were no allegations made in the complaint that Roger and Iran had sustained any loss of earnings between the time of injury and the time of death.
Very well. Thank you, Ms. Allen. Mr. Levine, you have, again, about 2.5 minutes in rebuttal.
Thank you, Your Honor. Let me start with a quote from Calhoun versus Yamaha. It's in our briefs, but what it says is that a prohibition against recovery of future earnings in a survival action appears to be quite suspect when the decedent is someone who is not employed, especially a child. Child does not typically support her parents, and so loss of support damages will be negligible. The child's expected future earnings, however, may be considerable. Allowing for lost future earnings under such circumstances raises minimal risk of duplicative recovery. In our view, to deny loss of future earnings under such circumstances gives a windfall to potential defendants. And that's really what we're talking about. I don't have your brief in front of you. Can you give me that site real quick? The site is Calhoun versus Yamaha Corp. USA 40 F3rd 622, 3rd Circuit, 1994.
Okay.
Now, the reasoning behind that is sound. And it's the same case that we have here, where we have a child who is not earning, but who suffers a death. And essentially what it would do is it would give a windfall to the defendants should their estates not be able to make these claims. Now, one of the things that Ms. Allen also spoke about was this issue regarding the burial expenses. she's right. The burial expenses weren't incurred within that window because they weren't buried until obviously after they were dead. But what if Uncle Jim, just as an example, is the one who pays those burial expenses? Can't the estate ask for that money back? And doesn't Uncle Jim have a claim against the estate for the money paid for those burial expenses? To say that we can't include burial expenses in a survival claim, again, it doesn't appear anywhere within the statute. Does that mean that only wrongful death beneficiaries are able to pay those expenses and be able to get them back? Another issue raised by Ms. Allen was the medical expenses. Medical expenses are incurred by a child. The child, in this particular instance, probably would have had his parents or an insurance company or something else pay those bills, but those bills belong to the child, not to the parents, not to an insurance company. They belong to the child. So what we're really looking at here is, what did the legislature intend to do by creating the survival statute? They intended to create a cause of action for a person's estate when that person dies, excluding pain and suffering damages. This is not pain and suffering damages. To the extent that Berrigan tried to create some window between injury and death, I would submit that lost wages, loss of future wages, medical expenses, and even burial expenses are within that window because they are all caused by the death of that person. Absent any additional questions?
Thank you, counsel, and your time has expired. It goes very quickly. We appreciate your briefs, counsel. We appreciate your presentation today. You've given us much to think about. We will take the matter under advisement and we will issue a written ruling in due course. So thank you all. Stay well. Court is adjourned.
Thank you.
Thank you.